Hello everyone. Today we will discuss on the topic suspension, remission and commutation of sentence which is discussed under chapter 34 from section 472 to 477 of the BNSS. Now before I go into detail in discussing these six sections, first I want you to understand the meaning of certain terms that we will come across while discussing this small subtopic. The first term is pardon. We all know that pardon is granted by the President of India under Article 72 of the Constitution and by the Governor of the state under Article 161 of the Constitution of India. Now, by pardon, we mean that it removes both the sentence and the conviction. We'll move on to the next term, that is commutation. Commutation, it reduces the period of sentence and changes its nature. Like, for example, a death sentence can be commuted to life imprisonment. A rigorous imprisonment can be commuted to simple imprisonment. And a simple imprisonment sentence can be commuted to fine. Then the next term is remission. Remission is nothing but it only reduces the sentence but does not erase the conviction. Like, for example, let's say that suppose a prisoner is sentenced to 10 years of imprisonment for a certain crime. Due to his good behavior and participation in the rehabilitation process, the government decides to grant him 2 years of remission. So, as a result of which, the prisoner will serve only 8 years instead of the full 10 years period of sentence. Then we'll move to the next term, that is suspension. Suspension is nothing but it is the stay of execution of sentence, which we have also discussed in earlier lectures and in the earlier sections of the BNSS. The last term which we need to understand is respite. Respite refers to the temporary postponement or reduction of a punishment. Usually, this respite is granted due to certain special circumstances such as like illness, pregnancy, or disability. But one thing you should remember is, unlike a pardon, a respite does not remove the conviction, but it provides temporary relief from the sentence. Now we'll take up the first section here, section 472, which talks about the mercy petition in death sentence cases. Now, this is a new provision altogether, which is inserted in the BNSS and which was not there in the Criminal Procedure Code of 1973. If you look at section 472, we have about 8 subsections there. We'll discuss each of these subsections in detail. If we take up the first subsection under section 472, it talks about the eligibility to file mercy petition. That is, who is eligible to file a mercy petition? A mercy petition can be filed by the convict who is under a death sentence. It can also be filed by his or her legal heirs, or any other relative may file a mercy petition before the President under Article 72 of the Constitution or before the Governor of a state under Article 161 of the Constitution. The second subsection here talks about the time frame for submitting a mercy petition. Now, this subsection says that the petition must be filed within 30 days from the date on which the superintendent of the jail informs the convict about 2 things. One is about dismissal of the appeal, review, or special leave to appeal to Supreme Court, or about the confirmation of the death sentence by the High Court and the expiration of the time allowed to file an appeal or special leave to the Supreme Court. The third subsection talks about the sequential filing. Now, initially, first, the petition may be made to the governor of the state, and on the rejection of the petition or disposal by the governor of the state, the petition can be made to the President of India within a period of 60 days from the date of rejection or disposal by the governor of the state. The fourth subsection here talks about what is the procedure to be followed for filing a mercy petition. The superintendent of the jail, he must first ensure that every convict in jail files the mercy petition within 60 days. If there are more than one convict in a case and only one convict files a mercy petition, and what in cases if other convicts do not file, then the superintendent should send the details to the central government or the state government for consideration along with the filed mercy petition of the one convict. The fifth subsection talks about the governor's role. Now, the governor here, upon receiving the mercy petition, the central government, it seeks the comments from the state government, then only considers the petition along with the case records and makes recommendations to the president, again, within 60 days from receiving the state government's comments and records from the superintendent of the jail. The sixth subsection deals about the final decision of the mercy petition. The president here, he will consider and decide on the mercy petition. If there are multiple convicts in a case, then the petitions are decided together in the interest of justice. The seventh subsection deals with how the decision is communicated. Upon the president receiving the orders on the mercy petition, the central government must communicate the decision to the Home Department of the state government and the superintendent of the jail within 48 hours. The eighth and the final subsection here is finality of decision. Now, once the president has passed an order on the mercy petition, no appeal shall lie in any court against the order of the president or the governor, which is made under Article 72 or under Article 161 of the Constitution. The orders of the president are final, and the process of arriving at the decision by the president or the governor shall not be inquired into by any court. Now we'll move on to the next section, that is section 473, which talks about the power to suspend or remit a sentence. Now, when any person is sentenced for an offense, then the appropriate government at any time, with or without any condition, suspend or remit the whole or only a part of the sentence. The second subsection here, it tells us that when an application is made to the appropriate government for suspension or remission of sentence, the appropriate government here, it may take the opinion of the presiding judge who convicted the person, whether the application should be granted or it should be refused. The third subsection under section 473, it talks about that if any condition on which a sentence has been remitted or suspended is not complied with, then the appropriate government, it may cancel the suspension or remission and direct the police officer to arrest the person and remand him to undergo the remaining unexpired portion of the sentence. Now we will move on to the next section, that is section 474, which talks about powers to commute sentence. This is an important section for you to lay a little bit of emphasis upon. That is, what is section 474 telling us or talking? It's saying that it gives the appropriate government the authority to commute sentences without the consent of the person who is sentenced. Now, what is the power that is being given here to commute the sentence? One is a sentence of death can be commuted to life imprisonment. A sentence of imprisonment for life can be commuted to imprisonment for a term not less than 7 years. Thirdly, a sentence of imprisonment for 7 years or more can be commuted to imprisonment for a term not less than 3 years. And lastly, a sentence of imprisonment for less than 7 years can be commuted to fine. And the last one is a sentence of rigorous imprisonment can be commuted to simple imprisonment. Then we'll move on to the next section, that is section 475, which talks about the restriction on powers of remission or commutation in certain cases. Now, there are certain restrictions imposed on the appropriate government in certain cases. Now, what are those cases? Let's see. The cases are where sentence of life imprisonment is imposed on the convicted person, but death is also one of the punishment, or the accused was convicted for death, but appropriate government commuted the death sentence to life imprisonment under section 474 of the BNSS, then in such cases, it shall not be released from prison unless he had served at least 14 years of imprisonment. That means the convicted person should not be released from the prison unless and until he has served at least minimum 14 years of imprisonment. Then let's move to the next section, that is section 476, which talks about the concurrent powers of the central government in death sentences. This section says that the central government and the state government has the same powers with regards to the death sentence. That is, this section 476, it grants the central government the concurrent powers with the state government concerning death sentence. Specifically, it allows the central government to exercise the same powers as the state government regarding suspension, remission, or commutation of sentence. Then we'll move on to the next section, that is section 477. Section 477 talks about the state government to act after concurrence with central government in certain cases. Now, this section 477, it stipulates that the state government must obtain concurrence from the central government before exercising powers to remit or to commute sentence in certain cases. Now, what are they? One is in cases requiring central government concurrence. That is, the state government must seek the central government's concurrence before remitting or commuting sentence in certain cases where the offense was investigated by an agency authorized under a central act other than the BNSS, or else where the case involves misappropriation, destruction, or damage to property which is belonging to the central government, or else it was committed by a person serving the central government while acting or purporting to act in the discharge of his official duties. Now, if you look at the second subsection under section 477, it very clearly talks about the concurrent sentencing involving the union. Now, what this subsection is telling us that if an individual is convicted of multiple offenses, and some of the offenses are pertaining to matters under the union executive powers and sentenced to concurrent imprisonment terms, any order of suspension, remission, or commutation by the state government will not take effect unless the central government has also made a corresponding order for the offense related to union matters. Thank you.